Hello y'all kids. Today I want to talk to you about organized crime in America. We're not talking about gun shooting or anything like that. We're talking about government officials doing white collar crime. Who am I? My name is Willis Louie. I am the plaintiff in Willis Louie versus University of Hawaii. Before I start talking about this case, I want to tell you that I want to make one point very clear. This is a no contest. The first day that they came into court, they already lost the case. Why? Because they defaulted the case. They didn't have a defense. They didn't show up to fight the case, so they lost the case. Defaulted and then default judgment. What does that mean? That means someone sued them, didn't show up to court, didn't answer the complaint, so therefore they lose. In 2008, I filed a lawsuit against the University of Hawaii and their faculty. Both of them didn't answer the complaint, didn't show up, didn't make an appearance. So why is it that 5 years later, the case is more than 5 years, the case is still in action? Why? Bullshit, that's why. The case has been won 3 times in a triple default. Why isn't it won yet? Because money, corruption, and bullshitting. Why not just answer the complaint? Why doesn't the University of Hawaii and their faculty want to just answer the complaint and fight the case? 3 reasons. 1, they will lose for sure. There's a stack of evidence and 4 witnesses, and the faculty expect to lose. So didn't show up to the UH meeting. Before you sue them, you have to exhaust all administrative remedies. But didn't show up for that. Filed the lawsuit, didn't show up for that either. So pretty much expected to lose. Second reason, they don't respect the law. And third reason is they're planning to buy justice. They're using money to buy law, pretty much. Basically, government agency using your money and my money to fight against you and me in a case they cannot win. How do you like that? They have, for 5 years, they have never attempted to fight the case. They have never ever answered the case. They have never attempted to fight the case. They refused to answer the complaint 3 times. I will talk about that triple default right after this. The only defense is they didn't get the complaint because they didn't want to answer it. They didn't get a complaint and you can't sue us. That's the difference. Basically try to avoid the whole lawsuit itself. So there's 3 things I want to talk about. Default, evidence, and bullshitting. Okay, let's talk about default first. So what is default? Default happens when someone files a lawsuit and you didn't answer the complaint. So you don't show up to fight the case. So 20 days later, you have a default. So what I have is a triple default. Let me explain each default. So first, we have a service or process, but it's a personal service. So you have someone, the server, deliver the complaint and the summons to the defendants, which is University of Hawaii and their faculty. And 20 days later, they didn't answer. That was the first. They both didn't answer. That was the first default. So the second default is when I did a certified mail. Now I didn't need to do this.
But I had a bad feeling. They didn't want to accept the legal documents.
they didn't want to get sued, I suppose. So I had a bad feeling. So when I did the certified mail, what I wanted to do is set up a good known address. Why do I need a good known address? Well, basically, the personal service was done to the same address, so they could try to deny the fact that they got the complaint and the summons. So if I could secure a good known address, that means that is a good address that I could send to, that could get to their lawyers or could get to their legal counsel. So once I file this certified mail and I have a return receipt, and then they responded to it. So once they responded to it, they cannot say that it's not a good known address because it got to them. So, but not only did it secure this, I want to set up the good known address, and also it secure a notification. What does that mean? That means this is a notice pleading. When you sue someone, it's a notice pleading. That means you have to let the defendants know that they're getting sued. So once they know that they're getting sued, they have to respond within 20 days. So now that you have a good known address, so this is the second time you defaulted, because we know there's a good known address, and we know that they got no notification of it. Okay, so the third default is when they make an appearance in court. The Supreme Court said that an appearance in court is as good as a service or process. What does that mean? That means you once you show up to court, you cannot deny the fact that you're getting sued. That means you can't play lawyer games. That's what it is. So you can't come to court and take off your pants, jump onto the table, start dancing and singing and say, you can't sue us, you can't sue us. That's what it is. So the Supreme Court eliminated that part where lawyers could just keep on playing games. But this bullshit judge, his name is Carl K. Sakamoto. Again, it's Carl K. Sakamoto. This guy is corrupt like a motherfucker. He allowed all kind of stuff that happened in this case that was not allowed. Basically, he doesn't follow the law. This guy is corrupt like a motherfucker. Okay, let's talk about evidence now. So the personal service, when I have a server serve the documents to them, the evidence that was returned was a return of service. So basically, here is the complaint and the summons in the back. Complaint and the summons in the back. So they delivered that document, and then they returned these two documents. This document for the return of service. And so the second evidence I have is the certified mail. Here is the certified mail. So here's the certified mail. There's two of them, and of course the receipts also. But another piece of evidence also is when they responded to the case. So the document that is sent back was also a piece of evidence to say that they have received that is a good known address that they have received my filings. And the third piece of evidence is the Supreme Court, the appearance in the Supreme Court. So basically, this is just basically a law book, some law in the law book. So here's the law. Basically, I don't know if you can see this. You probably can't see this. What it says is a general or voluntary appearance is equivalent to the service or process. And the citation is Humana versus Makeka, 25 Hawaii .597. So that's the citation number. So that's the evidence that for the triple default. Now you probably want to know what evidence the defendants have. Zero. They have absolutely no evidence at all. That's why it's very surprising that it lasted 5 years. That's why I'm here to explain what happened. Basically, they have no evidence. They have no law on their side. They basically use no logics either. If you look at their a lot of things that the judge did, there's completely no logics at all. The only defense was to say that we can't get sued. We didn't get anything. That's the only defense. Okay, so we've done the default, we've done the evidence. I will talk about the bullshitting now.